Nice little tripod.
Hello everyone, Yusef here. Today we're going to talk about discharging debt. I'm actually doing a private session, and I decided in this portion of the session, just this portion of the session, I wanted to kind of broadcast it and put some information out there for everyone that I deem that you may find very important. All right, so we're talking about discharging debt. All right, discharging debt. Now, a lot of people out there, everybody wants to know how to discharge some debt. All right, that's probably the number one question that I get all the time, or people wanting to have private consultations with me. They're attempting to discharge a mortgage or an automobile or something to that effect. Or they're trying to acquire some property or something like that. I get all of these type of questions all the time from individuals who are attempting to do something. Now, the first thing that I want to put out there is that discharging debt is not something that's simple to do. If you're going into this thinking, well, all I'm going to do is hand somebody a negotiable instrument and all my problems are going to go away, then this is not for you. Okay, you're in an adversarial situation, all right, because your opponent, they know that what you are doing. They understand what you're doing. They know that what you're doing is right, but they also know that if they allow you to get away with it, then you open the door, you open Pandora's box, and everybody else is going to be trying to do it too. All right, so you have to remember, if it was simple, everybody would be doing it. If it was simple, everybody would be doing it. So please don't enter into this with this notion that this is going to be a panacea or a cure-all for all your problems if you don't have the wherewithal, if you do not have the integrity to complete these processes. I really don't teach a lot of these processes all the time because there's a lot of misconceptions out there about discharging debt, and a lot of people are just making money off individuals selling particular information. But right now you're here with me, and today we're going to talk about discharging debt. Okay, so now number one, to understand, first of all, to discharge debt, you have to understand the first rule of the game is that there isn't any money. You have to understand this, all right, that there isn't any money. Now, if you don't understand that, a lot of you think that you think you know what money is. If you think you know what money is, I'm going to advise you. As a matter of fact, let me pause right here and tell people where to go. Everybody listening right now needs to go to my website, spcuniversity.privatesidesolutions.com, spcuniversity.privatesidesolutions.com. Go to that website and you will see a resources tab. Under that resources tab, you will see a PDF section. You need to go to that section right now because that is the reference information that I'm going to be discussing today as it relates to all the information that we are about to discuss. All right. So don't ask me where to get anything or anything like that. I put all the information for you for free in one location. You do not have to register with my website or be a member to have access to this information. It is readily available for you right there when you go to the website under the resource tab, under PDFs. All right, so make sure that you go there first. All right, the next thing I want you to go to the IRS Employee Manual. I want you to write this down. I want you to write down IRS Employee Manual Code 3.8.45.5.10.1. Once again, it's under the IRS Employee Manual. The IRS Employee Manual has all of the information that you need to understand how to discharge debt. Okay, if you're not the type of person that is a researcher and is inquisitive and has the wherewithal to go and investigate information on your own, then this is probably not something that is for you. Also, please share this right now with as many people as you can. If y'all watching this on Instagram, All right, share this with as many people as you can. All right, just share it. Make sure it gets out there. Now, why am I giving you this IRS employee manual code section? Well, that code section lets you know that bills of exchange are acceptable forms of remittance with the IRS. Now, I also want you to write this down too. These are the unacceptable forms of payment that the IRS will not accept. Now, why am I concentrating on the IRS? Because the IRS is the accounting norm. Everything that is involved in this country is about a tax. The criminal charges are a tax. Your car note is a tax. Everything is revolving around taxes. And most of you don't know what the definition of a tax is. Could you bring me that Black's Law 11th edition over there real quick? Let's look at the definition of a tax, and we need to look at the definition of a charge. Because a lot of you, it's real big right there. Appreciate that. Thank you very much. All right, this is Black's Law 11th edition. I got the latest edition. We're going to look up the word tax. Because this game is a word game. And if you're not constantly looking up words, if you don't constantly have a dictionary in your hand, then you're not really serious about this information. Do not ask me what the best dictionary to have is. You should be having all of them. Your job should be able to go get Black's Law Dictionary 1 through 11. That should be your goal, and they all should be on your shelf in your library. So don't go and ask me what is the best dictionary to have, because dictionaries all serve different purposes. All right, you can't use a modern day dictionary to get an accurate definition of the Constitution. You need a dictionary that was written during the time of the Constitution to get an accurate understanding of the words that are in the Constitution. Likewise, you can't use a dictionary that was written during the time of the Constitution to get some definitions about the internet law that we have today. All right, so we got different uses for dictionaries. Bouvier's is a very good dictionary. Can you have me them Bouvier dictionaries over there? It's 2 sets of them. They white. It's Bouvier's. And show these people these dictionaries. It's a 2-set volume. That's them right there. All right, this costs about $150 set. Brand new. These are Bouvier's dictionaries. These are some top-level dictionaries by Judge Bouvier. All right, Bouvier's Law Dictionaries. I got them off of Amazon. They cost me $150 because I will invest in my resource material. All right. Now, there is a debate on which dictionary is the best, but you should get all of them. You shouldn't even be worried about a debate or concerned about what dictionary is the best, because you should be having a reference library. All right. So let's look at the word tax. Because a lot of people don't think they know what a tax is. They don't know what a tax is, because they don't look up words and try to find out the meaning of words. All right, this is a word game once again. Once again, if you are not in the habit of picking up a dictionary, if you are the type of person that will read a book and pass over a word that you don't know the definition of, then this is not for you. Because the reason that you lack comprehension in a particular subject, or when you're reading particular material, is because there are words in the paragraph that you do not know the meaning of. The difference between successful people and unsuccessful people as it relates to this information are those who will pause and take the time to look up words versus those who are too lazy and shiftless and won't and will steadily come on live streams like this and ask questions. Hopefully, also, you're astute enough to know that I'm not answering any goddamn questions right now. So do not make me clown your ass right now. Hopefully you're respectful enough to understand that we're teaching class. You need to sit your ass down right there and listen to what I'm saying right now. All right, so we're talking about tax. So right here in the 11th edition of the Black's Law Dictionary on page 1758, we have a tax, a charge. Isn't that interesting? The very first word for tax is a charge. Likewise, when we look up the word charge, we will also see that it is a tax, as well as the fact that it is a lien. Okay? They're putting a lien on you. We're dealing with liens. We're dealing with a lien is simply an interest in property. Okay? Or some sort of encumbrance against property. So once again, a charge, usually monetary, imposed by the government or persons, entities, transactions, or property to yield public revenue. Most broadly, the term embraces all governmental impositions on the person, property, privileges, occupations, and enjoyment of the people, and includes duties, imposts, and excises. Now, here's the part that most people seem to miss. They'll look up the definition of a word, and I keep expressing that, and when I tell them about it, they look like a fucking deer in headlights. I say, will you please listen to this part right here in the definition of a tax? It will say, although a tax is often thought of as being pecuniary, the word pecuniary means money, okay? So although it's often thought of as pecuniary or something dealing with money, it is not necessarily payable in money. Now, what does that mean? That means that your tax sometimes is not payable in money. So how can it be paid if you're not using money? There's only other way to pay something if you're not using money is what?
Negotiable instrument.
Labor. That's a form. It's your labor.
Okay.
People want labor. So this is when they put you in jail and make you work it off. You're going to pay your debt to society.
Debt district.
All right. So that is the definition of the word tax. Now you also need to look up the definition of the word charge. Around the 5th or 6th sense of the word, you're going to find out that it is a lien. We're dealing with liens. All right. And there's only 3 ways to get rid of a lien: either payment in full, counter affidavit, or jury trial. You can't pay for anything because there isn't any money to pay for anything with. So you shouldn't even be using that word pay. A lot of y'all take it really lightly when I say that until your ass ends up in court and you got some charges on you just simply because you use the word pay or you put the word pay in some of your correspondence. You're not paying for anything when you're discharging a debt. You're discharging a debt. You're doing a set off. Okay, that is what we're doing. All right, you're not paying for a goddamn thing. Okay, do I need to express it very clearly for you to understand? Because I don't want to get a fucking phone call. I don't want a motherfucker to ask me for a motherfucking consultation. Not a goddamn thing. I'm telling you right here on this live stream what it is. You're not paying for a goddamn thing. House Joint Resolution 192 of June 5th, 1933, Public Law 73-10. There's nothing in that motherfucker that tells you that you can buy a goddamn thing. So don't call me and ask me how can I get a fucking car or a fucking house, because you can't buy shit with this. Do you understand?
Mm-hmm. That's right.
We're doing what's called a set-off. All right. So now, I gave you the code sections in the IRS Employee Manual. Another code section, you don't have your fucking pen in your hand. You better be at fucking work or driving or some shit like that if you ain't got a fucking pen in your hand.
Right.
Because I'm doing this shit for free right now.
This is valuable.
All right. So IRS, unacceptable payments. The section is 3.8.45.5.9. Once again, it's under the IRS Employee Manual, section 3.8.45.5.9. Let me say it again because everything does in threes. Unacceptable payments. 3.8.45.5.9. This is the type of shit the IRS doesn't accept. And you should also take this under advisement. You can't use none of this shit to discharge debt with. All right, not as it relates with the government. All right, they don't take gold. They don't take silver. They don't take jewelry. They don't take stamps. They don't take savings bonds. They don't take treasury notes. They don't take treasury bills, stocks, treasury certificates of deposit, promissory notes. And they're going to have an asterisk by a promissory note. We're going to go in on promissory notes because you got some gurus out there using promissory notes to discharge debt. A promissory note is a 2-party instrument. A bill of exchange is a 3-party instrument. And this is what goes with the secure party process because you're sending a bond to the Treasury Department. And as a drawer off of a negotiable instrument, they are the payee of that. I'm sorry, the payor of any type of any type of debt that you're trying to set off. All right. But just pause right there. Do not get sidetracked with what I just said. Let me continue. But I had to pause on promissory note because promissory note, they're telling you they don't take promissory notes. So if you're trying to discharge your taxes using a promissory note, the motherfuckers done told you right here in the employee manual, they don't do the shit. All right. They put it right in writing for you. Okay. So don't ask me no damn questions because they're telling you right here what they will take and what they won't take. Okay. So they don't take gold, silver, jewelry, stamps, saving bonds, treasury notes, treasury bills, stocks, treasury certificates of deposit, promissory notes, gold coins, deposit slips or withdrawal slips, credit cards, debit cards, gift cards, tickets to events, lottery tickets, obviously fake money. Did you find it over there on your side? Oh, you may not yet. Fake money such as monopoly money, oversized billion-dollar bills, currency copied with animals or other unusual items printed on the bill, etc., or expired or stale-dated checks. They don't take that, all right? Now, they have a note under here for you, okay? It says, if a promissory note is returned to the taxpayer and the taxpayer sends the note in again citing public policy HCR 192 for the note to the criminal investigation field office, attention special agent in charge of the state that taxpayer resides. Now, just because they send something to the criminal investigation division is not a bad thing. A lot of debt gets discharged to the IRS criminal investigation division. If you want further information on that, what I would advise you to read is What Does Acceptance for Value Mean by Byron Beers. What Does Acceptance for Value Mean by Byron Beers. It is on the SPCU website where he explains to you that the criminal investigation division is the cover for discharging debt. And Douglas Riddle is one of the first people that came out with it too. Douglas Riddle, you get on the internet, he has a video where he was actually talking about converting the coupons into money orders to discharge debt. Money orders were very successful at one time, but not anymore. Well, I don't know. They may still work because it's not on this list. All right, now, right here, they tell you that if you send it back again, if you use a promissory note and you send it back to them again, they're going to send it to the criminal investigation division. Now, you don't have to ask these people telling you what they're going to do with it. Now, I'm telling you what the criminal investigation division department is, though. You may get a call from them and they'll ask you, well, what do you want us to do with this? Okay, you tell them you want to post the credit. You say what I want you to do. I want you to ledger it on the balance sheet of the customer's account and offset that public charge and zero out the account. Okay. Douglas Riddle has videos on YouTube. You can watch those. Okay, on using money orders. All right, converting a coupon into a money order. All right, that was something that was very big back in the day. All right, so now, what do we just do? We just established, okay, what we're going to use, okay, some rules, because the IRS is the accounting arm of the Treasury Department. All debt that is discharged is going through the Treasury Department. Now, they are the accounting arm for the Treasury Department. Now, we are not talking about money. We're talking about accounting. Okay, these are all accounting procedures because we're not dealing with money of exchange. We're dealing with money of account. Now, if you do not understand the difference between money of exchange and money of account, some more reference material that I'm going to suggest that you read is the affidavit of Walker Todd. It is right there on the SPC website in the reference material. It is a case where Walker Todd, who is an attorney, served as an expert witness and explained on the record the difference between money of account and money of exchange. All right. All right. All these mortgages and these car notes that you're getting, you didn't get anything of substance for that. If you don't believe me, just go in there and ask the motherfuckers. All right, next time you buy a car, ask them very clearly, where is the money coming from that you're loaning me for this car? You're claiming that I'm getting a car loan. Okay, can you give me the account number that the money is coming out of and it's going into my account? And they can't say that it's coming out of depositors' accounts because if they take money out of depositors' accounts to loan to someone else, that is against the law. All right? So understand that part first. All right, so we're getting some fundamental things here. We got to remember the 4 rules. There is no money. Public and private don't mix. Staying on at all costs. And do not participate in public controversy. We're not trying to cause a controversy. Understand that there is no money. Okay? The gold rescission that happened in 1933 has been codified in 31 United States Code 5118. 31 USC 5118. HJR 192 is just a resolution. So if somebody's out there saying that HJR has been rescinded, that's a dumbass nigga, and tell them to get out of your face. Because it's right there in the damn United States Code 31, Title 31, Money and Finance, Section 5118. Rescission of the gold clause. Now, when they rescinded the gold clause, which is unconstitutional, they made it constitutional by removing it from the republic and putting it into a legislative democracy. That's why you keep hearing all this talk about democracy. The word democracy is nowhere in the Constitution, and the word democracy don't mean shit about freedom. So get that shit out of your mind. Okay, so we got some fundamental principles laid down. We understand what they will and will not accept. Okay, we just read what they won't accept. Well, let's read what they will accept. Right now, we're in the Employee Manual of the IRS, section 3.8.45.5.10.1. Once again, that's the IRS Employee Manual, section 3.8.45.5.10.1. I'm in the section that deals with acceptable and unacceptable forms of payment. All right. When you get to the IRS website, you can put the search bar and you can put that in there and you can find it. But I'm giving you the numbers and you can go down until you see those numbers. Once again, that is section 3.8.45.5.10.1. And then we're dealing with bills of exchange. And they're going to tell you very clearly, if a bill of exchange or registered bill of exchange is received from a taxpayer authorizing, now we need an authorization. That's another thing. When you discharge debt using a bond with the Treasury Department, you have to give an authorization for someone who's going to utilize that bond. So if a bill of exchange or registered bill of exchange is received from a taxpayer authorizing the campus to settle their account, okay, through FedWire, send everything to the following address. And the address that they're going to send your bill of exchange to when you send it in is the Department of Treasury, Office of Executive Secretary, 1500 Pennsylvania Avenue Northwest, room 3413, Washington, D.C., 20220. Now, isn't it strange that this happens to be the very same address that you send your bond in when you do your secured party process? Now, I want you to understand something, that when you're doing a secured party process, another name for it is called private banking. Okay, we got public and private. When you're in the public, they do everything for you. When you walk into the bank, they ask you, they open you up an account. They already have some pre-checks already printed out, already has the account number on it. All they need to do is add your name to the account. It has routing numbers on there with the account number, the check number. They ask you, oh, okay, sir, well, what would you like to start your checks at? If you're an astute person, business person, you understand that you don't have to start your checks out with low numbers. You start them out with high numbers because low numbers on checks look suspicious. Okay? All right. So you're going to have some high numbers. But anyway, they do that for you. Now, on the private side, nobody's doing anything for you. Why is nobody doing anything for you on the private side? Because you have to demonstrate that you are more than competent enough to handle your own commercial affairs. That is what got you into this predicament in the first place, is because you are lazy, you refuse to educate yourself, and you want somebody to do something for you. And the federal government is doing something for you, and you're looked at as an incompetent and somebody who can't handle their own commercial affairs, and they're handling all your business for you. All right, because you're not sophisticated enough to do these things that I'm talking about right now. Okay, when in antiquity, negotiable instruments is what the colonists used. You can get on Google Images and you can look up the first colonial script. And then when you had the, what was that, the War of 1812, I think, when they fought against, I don't think it was fought against the colonists and everything because they wanted to use their own script. And the Rothschilds didn't want them to do that. They wanted them to use, you need to use our stuff. That's what that was all about. We was always making our own negotiable instruments. So please don't think that the banking industry or the federal government has some sort of monopoly on using negotiable instruments. They are public servants. They copied everything from us. We created all of that and we allowed them to do that. They're supposed to be doing it for us. So don't think anybody can make a negotiable instrument. You just don't need to put routing numbers on your negotiable instrument. The first time you give a negotiable instrument and you send it somewhere, it's going to go to the legal department of that particular place. And the first thing that they're going to be looking for is anything on that negotiable instrument that is public in nature. If they find anything public in nature on that negotiable instrument, you have the possibility that they're going to put a charge against you. All right, so all of your negotiable instruments have to stay private. As long as everything is private, no one can do anything to you. No one can touch you. The only time they come bother you is because you're fucking around in the public side. The public side is their domain. The superior man stays in his own domain. That's a maxim of law. The superior man stays in his own domain. Understand that. All right. So now, what do we have? Let's recap. All right. We got the code sections in the employee manual. We understand that they have some unacceptable forms of payment. We understand what will happen if we use a promissory note, that it will go to the Criminal Investigation Division, probably in Ogden, Utah, or someplace like that. I think they have like 4 of them on different campuses in the United States. So if you use a promissory note, there's a possibility, well, they've been directed to send it to the Criminal Investigation Division. We also know that that's not necessarily a bad thing. However, you may receive a phone call from the IRS in trying to find out what do you know, and you need to be prepared for that phone call. However, if you use a bill of exchange, we know that they have directed you to send that to the Department of Treasury at 1500 Pennsylvania Avenue and room 3413 in Washington, D.C. All right. Now, none of this stuff that I'm talking about is speculation. You can read the shit right here off of a computer and they'll tell you what the fuck to do. Okay? So none of this is speculation or anything like that. All right? So now what is the difference between a promissory note and a bill of exchange? A promissory note is a 2-party instrument. It doesn't have to be supported by anything. And a bill of exchange is a 3-party instrument. It's very similar to a check. Okay. Usually there's a drawer and a drawee and a payor and a payee. Okay. The drawer is you. All right. The drawee would be the individual that you're giving it to. Okay. The payor would be the individual responsible for transferring the credits into an account. And the payee is the person that will be receiving those credits, when likely would be the individual you're discharging the debt with. Now understand that no money is actually changing hands here. In your system that we have out here today, there isn't any money changing hands. When you use a debit card or anything like that, it's just some numbers going through a computer system and somebody ledgering something in a book. There isn't any money because there is no money. We're dealing with credit. All right, so get that out of your mind. Ain't no money flying around electronically all through the air or something like that. We are talking about accounting procedures. Somebody's on one end doing a credit and somebody's on the other end doing a debit. Once again, if you seem to, I know we got some people who are just logging in, but if you don't understand the difference between money of account and money of exchange is gold and silver. Money of account is negotiable instruments. You don't have any money of exchange in your system anymore. Money of exchange is gold or silver, or instruments that can be redeemed in gold and silver, like silver certificates and gold certificates. But if you don't have that, which is not acceptable in a lot of places in our society today, we're primarily using Federal Reserve notes. Federal Reserve notes is not money. Federal Reserve notes are negotiable instruments. They are debt currency. So the Federal Reserve is also not a governmental entity. They are a private institution. You are a private institution. You have just as much right to make a Federal Reserve note, make a private promissory note as the Federal Reserve does. The only difference is this. All right, those Federal Reserve notes are circulating in the jurisdiction of the United States. The jurisdiction of the United States operates outside of the Constitution. Okay, they have the delegated authority to do that pursuant to Article 1, Section 8, Clause 17 of the Constitution, which incorporates that 10-mile square in Washington, D.C., along with all their insular possessions. The primary principle that allows them to do this is called, plenary power. The word is plenary, P-L-E-N-A-R-Y, plenary power. The Congress has plenary power over their insular possessions and anything that they create. And what that essentially means is the other two branches of government cannot form a check and a balance on anything that has been delegated to them under their complete authority. So this is how, for a lot of you people saying that Federal Reserve notes are unconstitutional, that is not necessarily true. It is very constitutional. They took it outside of the jurisdiction of the United States, and how they got you to participate in it is through contracts. This is why we're always talking about contracts, because private individuals deal in contracts, and contracts are either express or implied. It doesn't necessarily mean that you had to sign your name on something. The implication comes through your conduct by you voluntarily accepting benefits or privileges in some shape, form, or fashion from the federal government. All right, now, so we got some fundamental things. Everybody said on what I just said right there. All right, so the next step now, you need to know how to put together a negotiable instrument. If you want to know how to put together a negotiable instrument, you're going to have to come to my class and register at SBC University, because this ain't what this is right now. All right. The next step is once you understand how to put together a negotiable instrument, well, what is the process, Yusef, of discharging the debt? Well, the first thing that you have to do is you have to request from whoever that debt is that you have that they give you a payoff statement. There is a reason that you always ask for a payoff statement, all right? And that is accord and satisfaction by use of an instrument. All right, and that is UCC 3-311. UCC 3-311. Once again, I hope that you have a pencil in your hand and you're taking copious notes. All right, so accord and satisfaction is what we're talking about. All right, now when you read accord and satisfaction, essentially what is being done when you talk about it, especially under subsection C1, that is giving you a description that if you discharge a debt, but if you give them another negotiable instrument or something, the debt will not be discharged. So under UCC 3-311, it outlines for you how a debt is discharged and how a debt is not discharged. You also need to be familiar with UCC 3-603B. Okay, that's tender of payment. Okay, when you give somebody a negotiable instrument and they refuse to accept it, the debt is discharged. Why is it discharged? Because if they won't take a negotiable instrument, they can't take nothing, because the only thing we have in circulation in the world today is negotiable instruments. So if somebody refuses to take a negotiable instrument from you, then they don't want nothing from you in the first place. And Federal Reserve notes are private script from the Federal Reserve, which is a non-governmental entity. Now they have a monopoly in that system. That's why you have to do the secured party process, because you need permission, to what's called other instruments within the jurisdiction of the United States. And that's why we do the first step of the secured party process. You're sending them a notice, and giving them 30 days to respond. And in that notice, you're letting them know, once I'm going to give you a bond, that bond is going to be for the sole purpose. The principal off that bond is going to be for the sole purpose of offsetting obligations. Any windfall that you receive from the interest on that bond is for you to use, all right? Because you got to give the government something too. They're going to take your bond, put it on a trading platform or something else like that. What are y'all talking about? UCC 603B, not 336. UCC 3-603B. It's tender event. UCC 3-603. UCC 3-603B. Okay? Understand that, all right? All right, so we got that part down. All right. So now the first thing you're going to need to have after you get the payoff statement, because the payoff statement is going to direct where your negotiable instrument has to go, is going to give the amount, because you have to have the exact amount, and that's going to be calculated for 30 days with the interest, principal, and everything that is associated with it. So you always ask for a 30-day payoff first. All right. Once you get that payoff demand, the next thing you do, you draft your negotiable instrument, and you're going to have to recruit the services of a notary. Now, let me speak about a notary very for a quick second. Please do not come to me and ask me how I can't find a notary. Okay, I understand that some of y'all ain't got no hustle about yourself whatsoever. Okay, I'm a hustle and everything. All right. In Georgia, it costs $30 to be a notary. In South Carolina, it costs $60 here, $30 in South Carolina. The most expensive place in the nation to become a notary is in California. I believe it's $500. All right. If you're going to do this process and you can't find a notary that will help you, then go make your own damn notary. Okay. A wife can notarize her husband's documents, and a husband can notarize a wife's documents. All right. Find a girlfriend. All right. Somebody like that. You know, one of these girls out here ain't making no money or nothing like that. Tell them, hey, look, you want to make some money? We got a group of people that need a notary. Let me take you up here and make you a notary, and you're going to notarize all our documents, and we're going to compensate you for that. All right. The notary also needs to have their own P.O. box, all right, because all correspondence is going to go through the notary. Nothing is mailed by you, and nothing should be received by you. Let me say that again, because some people seem to be very slow on the uptick when it comes to this particular point. Okay, if you are out there trying to discharge debt and mailing it yourself from your address, you don't know what the fuck you're doing. All right? Because everything should be done in contemplation of having to end up in court. All roads end up in court. In court, you need two witnesses. Your witnesses, a notary is a witness. Your other witness is a certified mail form, the form 3811. You're going to get that return receipt and have it returned to the notary's address, and they're going to bring it to you. All right, and you're going to put that in a file. All right, so you need two things. You need a notary, and you're going to send things certified or registered mail. We're dealing with negotiable instruments. You always send it registered mail. Now, that forced correspondence, if y'all download Creditors and Their Bonds off of my website, I'm going to read a letter to you first. We're going to go through real quick this administrative process, all right? Did everybody get everything they needed? All right, I'm going to save the video. Y'all can replay the video later. Okay, and I'm going to go back over everything that I said, because I'm only going to do this one time. I ain't doing this no more. All right. So when you go on the SBC University website under Resource tab, click on that. You're going to see Creditors and Their Bonds in the first column. There are three columns. Right at the top, the very top left column is Creditors and Their Bonds. You're going to download that, and then you're going to go. The first stop you're going to make is on page 19. If you're using a PDF viewer, look at the page numbers at the top of the viewer and go to page 19. You're going to see a notice of pre-authorized use of credit. Now, what does this notice consist of? Well, let's think. We're doing private banking, right? Okay. You know, if somebody's trying to access credits off of your bond, shouldn't the Treasury Department be apprised of that fact first? So shouldn't we send a notice to the Treasury Department and say, hey, look, man, remember that bond I sent you last year? Well, if you don't remember, here's the registered mail number that I had attached to it. Now, you do understand that you're the holder of that bond, not the holder in due course. You know why you're not the holder in due course? Because I put that bond on a UCC1 and sent you a notice of that fact that I have it on a UCC1. And that's the requirement under UCC 3-302 to give notice of that I have holder in due course status. So any type of proceeds that are derived from that are to come to me, unless, in this case, I've allowed you to have it, the windfall of it, as well as the fact that that bond has to be returned to me. Because I put it in the tenor of the bond. If you read in the bond, it says after 30 years, you need to return it to me. The reason you return it to me, because I'm the holder in due course. If you don't understand what a holder in due course is, you're going to have to join SBC University, because that ain't what this is about right now. All right. So we're going to give a notice. Okay. And that's UCC 1-202, giving notices. What constitutes a notice? We're going to send certified mail a notice to the Treasury Department to apprise them of the fact that you are about to discharge some debt. You're going to let them know the account number. Why are we going to give them an account number? Because you got to tell these people how to locate the account. We're going to give a description of the instrument. We may even send them a copy of the instrument. We're going to send them a copy of your 30-day payoff notice and let these people know that, hey, look, there is somebody that's going to be coming to discharge a debt. They're going to be contacting you. All right? They're going to be contacting you. Now, it don't have to look like this. You can make it look like however you want to make it look. It just needs to contain all the vital information on there, and it needs to be one page. Okay? Let me tell you something. All right? All correspondence that you submit when discharging a debt should be one page. All right? When you sending shit to motherfuckers and it's 15 pages, you don't know what you're doing. Nobody's going to sit down and read all that bullshit. Okay? Nobody's sitting down and reading that bullshit. All right? When you put it into court or anything like that, nobody's reading all that shit. You put it on one paper. One piece of paper. You need to say everything you need to say on one page. And we got plenty of examples of that. We're going to go through it right here. So our first stop is we have a notice of pre-authorized use of credit. All right? That's going to the Treasury Department. The purpose for that is to let them know, to give them notice, advance notice, that you're going to be discharging some debt. All right? So what's the next stop? Let's go to the next page. The next page is what? A notice of acceptance. Now, if you look up at the top, you will see that the address the from address is your notary's address. Your notary should have a stamp, a seal, the little crimper type, as well as a stamp. And they should also have a notarial record book. The notarial record book can be put into court as evidence. The only purpose the notary has is as a witness. That's it. They are not involved in this process other than mailing some information for you and then also being a witness of when a particular mailing returned to you. Because this is an equitable proceeding. It's involving latches, which is under the principle, those who sleep on their rights have none, okay? In other words, time is of the essence. So it's 10 days they got to respond. The 10 days comes from 3 days because it's 3 days, 72 hours. The rule of 72 is what creates a contract. Now, if y'all stand to the 72 entities that are around the earth, the zone that girdles the earth. If y'all put the 72 entities of the zone that girdles the earth, that'll be some interesting reading for you. All right, an angel and a demon, every zone of the earth. Just letting you know. So we're talking about 72. So 72 hours, but you have 3 days mailing time for it to get to them. After they receive it, they got 3 days to decide what they're going to do with it. 3 days return mail, 1 day for Sunday. That's where you get 10 days from. So right here, we have our next letter, which is your letter of acceptance. Let's read it real quick. Page 20, on the creditors and their bonds. So here's the very first letter. It says, as it is my intent to expedite the process to reach settlement and closure of this matter as soon as possible, I have accepted your letter demand, or whatever it is, you've accepted it, for value. Now, let me just stop right here. If you know the exact amount, it is accepted for assessed value. If you don't know the amount, it's just accepted for value. All right. So if you got the exact amount, it's a mortgage or a car note or something like that. Okay. I've accepted it for assessed value, endorsed it, and I'm hereby returning it to you in exchange for the discharge of the charges using my exemption. Your exemption is your social security number without dashes. Your social security number, it constitutes what is called a closed account. Why is it a closed account? Because when you look at the definition of closed account in a Black's Law Dictionary, it is closed for debits and credits, but remains open for offset and adjustment. And that's what you're utilizing it for, to set off debt. It's closed because you're not using it to add credits and debits. You're not using it to work a job. You're not using it to get credit with. You're not doing anything with that particular number that's going to constitute a credit and a debit on that account. But you are using it as a reference number and letting them know that you are a beneficiary in the Republic. You're a private citizen. And this particular number right here, you take it off the dashes and you're utilizing this to set off debt in the public. All right. So let me read it again. As it is my intent to expedite this process to reach settlement and closure of this matter as soon as possible, I've accepted your letter, demand, or whatever, for value or assessed value, endorsed it, and am hereby returning it to you in exchange for the discharge of the charges using your exemption, which is your social security number without dashes. I do not dispute any of the facts. Now, why are we saying we don't dispute the facts? All right, because whenever there's a dispute, okay, remember the fourth rule, you do not participate in public controversy. When you create a controversy, okay, that is creating something that can only be resolved through fact finding. Fact finding is when you go to a jury trial or a bench trial. They're called fact finders, okay? Because before you can get to the law, you have to determine what the facts are. And if we are in a dispute, that means we don't know what the facts are. All right, so we're going to circumvent this in the spirit of the Bible in Matthew 5:25, when it says, agree with your adversary while you're on the way to court, lest he hand you over to the judge hand you over to the bailiff, and the bailiff cast you into prison. I tell you, you will not come out until you pay the very last farthing. I'm sure you've read that in Matthew. Okay, that is typical. That's a principle involved in this. You don't want to get into any argument with these people. The reason why is because you're the creditor and you have an unlimited exemption. Why would you argue with anybody about a debt when you're discharging a debt? The reason that you can discharge a debt because you're the creditor. Now let me take a sidebar for a second and talk about why you are the creditor. You're the creditor because the United States is bankrupt. It's on the public record. In 1933, they're bankrupt. Go to usdebtclock.org and stare at it. For all of you saying they're not in bankruptcy, they're $28 trillion in debt. They're bankrupt. So the only way you can discharge debt is you have to have the proper status. That status being that you're a private person. You cannot discharge debt as a U.S. citizen. You had to be private. And how you be private is you let them know. Because a lot of you have been fooled into being a U.S. citizen. If you want something to read about that, there's reference material in sbcuniversity.privatesidesolutions.com. Under the resource tab, go to the PDF section and download a document called the Affidavit of Sovereignty and study that. So let's continue reading this letter. If you have evidence to the contrary or that my process, wait a minute, hold on, let's say, I do not dispute any of the facts. We don't want to get into a dispute. My records indicate that the balance on the account, and you're going to give the account number, is 0. If you have evidence to the contrary or that my process for settlement is prohibited by law, please send a full accounting or the prohibiting law upon which you rely to the notary identified above within 10 days of your receipt of this notice of my acceptance. If you have no reasonable commercial excuse for delaying the settlement of the account, please settle and adjust your records and send confirmation of the same to the notary identified above within 10 days of your receipt of this notice of my acceptance. In the event you choose not to respond to this notice and request, I will accept your silence as your agreement that the balance on the account is 0, and I will settle the account myself through registration. The registration that he's referencing is in the UCC commercial chamber. Also, your silence, we do know that that is a principle of law, that silence is acquiescence, meaning that you agree to something. Now, we have this principle for you in Georgia. This is codified under statutory law. It's codified under failure to answer a business letter. Let me give it to you. This is just for people in Georgia. It's OCGA 24-4-23. OCGA 24-4-23. Now, you don't have to be in Georgia to use the verbiage that's in that. Let me read that to you because it's a principle of law. This statutory code is based off the principle of law. Silence is acquiescence. So right here, we can say in the ordinary course of business, when good faith, and we're dealing with good faith, that means we're dealing with an equitable situation. We're dealing with equity, which is when you're discharging debt, it's equitable. Equity is fairness, impartiality, and even-handed dealing. And we're coming from the republic or the private side. And under the private side, we're dealing with God. Okay, and God judges with equity. If you don't understand that, Google it. God uses equity to judge. All right, so in the ordinary course of business, when good faith, equitable principle, write that down, requires an answer, it is a duty. Duty is the key term right here. A lot of people think they can just discharge anything. You can only discharge debt when somebody has a duty to respond to you. Duty is a very key term. Let's pause. It's so important, okay? And it seems so innocuous to a lot of individuals, and they'll just roll over that word without taking the time to really investigate it. We're going to take time to look at this word duty. What constitutes a duty? I'm in a Black's Law 11th edition. Got the new one. Amazon. Duty. Page 637. Look at all of this verbiage under duty. I mean, some long, look at all this stuff under duty. They really want you to understand what a duty is. You know, it's like a lot of stuff under here. Duty, a legal obligation that is owed or due to another that needs to be satisfied. That which one is bound to do and for which somebody else has a corresponding right. So there has to be some corresponding right, but rights are only enforceable through contracts. I hope y'all know that. Read the 10 commercial maxims of law, okay, where it tells you have to express something. You need to put it in the form of a contract. It's page 637, Black's Law, edition 11. So, study the word duty, put that on your vocabulary list. You should know what a duty is, all right? So, it is the duty of the party receiving a letter from another to answer within a reasonable time. Now, sometimes when you're discharging a debt, it's not always 10 days. Okay, like if we're doing something under the Fair Debt Collection Practices Act, okay, that particular act is regulated by statute. And you got to go in accord with what the time frames that they set in those particular statutes, which I believe is at about 20 days. So if you do a verification of debt or a request to somebody like that, you got to use their time frame. You cannot make up your own time frames. Understand that. But you still use the administrative process in those particular situations as well. So I just got through reading OCGA 24-4-23. You do not have to be in Georgia to use that because that particular statutory code is based off of a principle of law that silences acquiescence. The verbiage in there is something that everybody can use. However, if you do use the verbiage, you cannot cite the source. But you are more than welcome to use the verbiage because it's based off of a principle of law. All right? Got 135 people on here. Y'all are not sending out enough notices and sharing this information. You are being selfish right now because there should be a lot more people on here than that. All right? So, right now, everybody flowing with me right now?
Yep, we're with you.
Y'all flowing with me. All right, we getting some fundamental things down. All right, recap once again. We started with the IRS. We found out what kind of instrument we can use. All right. By going through the IRS employee manual, there's a cornucopia of information in there for you to read and find out some additional information, a lot of secrets in there. I remember there was a story somebody told one time. This is like an urban tale as it relates to this secure party stuff, that there was a gentleman who had been studying this for so long that he just got tired and he said, I'm going to study the entire IRS manual. And he found the code, and the IRS employees, when he called them, they said, welcome home, brother. It's an urban legend. The answers that you're looking for is in Title 26 and the employee manual. All right? Okay. Let's keep going. So in the recap, we found out what kind of instruments we can use. We know that we have to give the Treasury Department a notice. All right? And then we have to find a notary. We're going to be diligent and proactive in getting our notary because we know it don't cost a lot to get a notary. You know, you're going to get your girlfriend or your boyfriend or somebody just sitting on their ass doing nothing, not making any money, and you're going to employ their ass. You're going to put them to work and say, look, I'm going to take you down. That's what I do. I'm a hustler, man. I'm like, I need a notary. You know what I do? I'm meeting girls all the time. I said, say, baby, what you doing? She ain't doing, you ain't making no money? Hop in. Let's go down here real quick. I'm going to make you a notary. I'm going to put you to work. I think I can help you make about $1,000 a week. Do any of you niggas got any game anymore? Because I see a lot of motherfucking simps out here right now. You know what I'm saying?
That's right.
These niggas act like hoes right now, man. They let these women, look at this rap music, man. You got this, put this bitch on this stallion broad and everything. They're talking about they're pimping niggas and shit. How y'all listen to music like that? Y'all letting these women, nigga, sitting here talking about pimping y'all and shit. And you accepting that shit. You ain't be listening to that shit, man. Fuck wrong with you? You better put these women back in their place, nigga. Right. Now let some woman pimp you.
Same.
Nigga, I'm from the old school. I wish somebody would. I wish one of you would say something. Come and say something like that. Come and let that motherfucking rap music program your mind and shit. Get it out of your mind, all right? Get it out your mind, because that ain't reality. They got y'all ass in fantasy land somewhere, all right? I don't know. It might be working on the next generation, though. I don't know what I'm saying. You know what I'm saying?
Doing all the shit they talking. They ain't doing it. They just showing.
They ain't doing that shit for real. I know what I'm saying. But, you know, it's like, I be listening to that shit. I be listening to that rap like, man, what the hell fuck she talking about? And they be rapping that shit, too. Yeah, nigga, they lick, give me head. When the broad start talking about giving tell a dude to give her head. Like, give her head shit. That's motherfucking nigga shit. You know what I'm saying? You act like a nigga. You know,
motherfucker attracted to that.
I know what I'm saying. You know, I was like, okay, let me get back. I had to keep it real for y'all, for real. For real. Get your notary, all right, dog? Get your notary. Put somebody's ass to work, okay? Find out how you're going to do it, all right? Be a man or something like that, because I don't understand what's going on out there, because I get a lot of people be coming to me asking me how to do shit, all right? And I don't understand it. Where your hustle at? All right, where your creativity? Where your investigation?
Don't know how to do shit.
I know there ain't nobody do nothing. You know what I'm saying? You know, I can't get a notary and everything. You know, nigga, go make one. You know what I'm saying? If I can't find it, I make it. All right? Let's keep it real. I have respect for the black queen. I don't got respect for if she thought that she acting like a nigga. I got respect for a woman that is feminine. And I got respect for a queen when she understands I'm the goddamn king.
Ain't no lack of disrespect.
Ain't no lack of disrespect.
That's the truth.
It's disrespectful for you to come at me like a nigga. That's disrespectful. That's disrespectful. Don't be looking at somebody came on my on my Instagram because I post that little thing and she talking about what real men should be paying thing, what to how y'all was raised and all that. I said, look, don't come on my channel and questioning my manhood. Ain't no woman ever been with me had to pay a goddamn thing. All right? Anybody knows me knows that. I've been a man since I was born. It's some of y'all can't appreciate that shit or know how to handle high value man, and that's why you need to take your ass over there and listen to Kevin Samuel. I don't give a fuck how feminine y'all think he is. That reason he handling y'all ass because he got that masculine and feminine thing going, and he telling y'all stupid ass the truth. So go over there, take your ass and listen, because some of y'all don't know how to handle no high value man. Because that high value man shit, all that masculine shit, you ain't getting no play over here with none of that.
Bullshit. Oh, you know what?
Get that shit out your head, all right? Because when you're dealing with high-value men, we going to kick your ass out. You get the fuck out.
Ain't dealing with that shit.
We ain't dealing with that. Get the fuck out of my fucking house.
Hell yeah.
All right, so...
I'm just quick.
Yeah, go ahead.
I just opened your book. I just opened it. And this may be relevant or some coincidental shit, but it opened to when his discharge will not be granted.
And this is right when discharge. And he have it right here. When discharge will be granted, and we're looking.
I just opened the book.
Yeah, and it's right here. When they got this whole section dealing with set off. Let me see if this is the one dealing with set off right here. Because yeah, Bouvier's is very, very good. Duties of assignees, and it's right. That's banned. No, this is under ban. So we're talking about when somebody gets banned. But they got
ban mean in reference to
on the matter of declaring a person as involuntary bankrupt.
Oh,
now involuntary bank when discharge will not be granted. This is like in bankruptcy.
Okay.
But they do got a section. I'm gonna pull it up that talks about lists 10 different ways of what a discharge is. When you discharge, I can't remember if it's in Bouvier's or in or something like that. You know what I'm saying? All right, let's get back. We talking about this discharge, all right? Let me recap again. All right, once, because we got some new people in here, and you might have been kind of new and you didn't catch on to some of the things that was being said. All right, we're talking about discharging the debt. All right, we started with first and foremost, we looked in the IRS employee manual. I gave you the code sections to look at for unacceptable payments and what they do with a bill of exchange and what they do with a promissory note if they receive that. You have to understand that the IRS is the accounting arm of the Treasury Department. You have to understand that there isn't any money. If you don't understand there isn't any money, you need to read the affidavit of Walker Todd as well as Modern Money Mechanics. Those are two documents that you can get. Okay. You need to understand that you have to be private to discharge debt because they are bankrupt in the public. All right. Why do you have the capacity to do that? Read the affidavit of Walker Todd. As a matter of fact, you can put the affidavit of Walker Todd in as an exhibit on a case. Yes, ma'am. What, you gonna cuss me out about something? You watching my live stream? Huh? Hello? Hello? Hit your mute button. I ain't say nothing. Anyway. All right, so what we doing? Okay. Now, we got creditors and their bonds. You went over to sbcuniversity.privatesolutions.com. All right. Got on the section on there that says resources. Got the PDF section. Went to the first column. Very first document says creditors and their bonds. You downloaded that document. You went to page 19 where it's going to have all of your forms because you do not have to make these up out of your mind, out of the belfry of your own imagination. All the one-page documents are already pre-written for you. They are very well-written documents, okay? Matter of fact, you don't even need to really change them much. And right now we're on page what? 20. And so page 20 is the document that you're going to send with your negotiable instrument. You're going to get a notary. The notary is the one that's going to mail it. Your notary should have their own P.O. box. That P.O. box address and that notary's name is going to go at the top. You do not mail anything. The notary mails it because the notary is a witness. You need 2 witnesses. All roads lead to court. The first witness is the notary. Second witness is the postal service. Your form 3811, the green form that you get back when you mail something off, whether it's registered or certified mail, that's coming back to you. Those 2 things are going to be used as exhibits if you ever go back in court. Exhibit A is going to be the certificate of non-response from a notary. Exhibit B is going to be your form 3811. Those 2 documents right there are going to serve as prima facie evidence that you did what you were supposed to do under UCC 1-202 and gave notice to these individuals that you tendered a negotiable instrument for full satisfaction of this obligation, that they did not return or respond to that, and their silence constituted acquiescence, which is an equitable principle. We're going to, even if we use the verbiage under failure to answer business letter here in Georgia, understand all that. You can use statutory verbiage as long as you don't cite the statute, because when they write these statutes, they are based off principles of law. The principles of law are not codified. Okay, you got to understand that code sections come from the common law. These statutes, they copying from us. They copying from real law. Okay, so their little artificial law, their little fictitious law is based off of principles of law.
And if you use them, you're stepping into the fiction.
You're stepping into fiction, so you can use the words, the principle involved is what you are interested in. Yeah, don't use their code, because the codes are based off principles. It's the principle that we're looking for. You study principles. That's what we're interested in on the private side. We are interested in principles of law. Okay, and principles are few and methods are many.
If you use their statutes, that could lead you into a public conversation.
You're mixing public and private.
That could lead you to a public conversation.
Exactly. What we're doing right now, we are doing this privately. Right. So everything involved in what we're doing is private. You're not using any code sections or anything like that in any of your correspondence. It shouldn't even be involved in there.
Public and private don't mix.
Public and private don't mix. All right. So we're not using any of that information. Okay. You don't ask for a notary. Go make one. I just said that. Go back and read. Because you tell somebody just they're new. They keep asking, well, how we get a notary?
Get a notary. Get somebody.
I just spent about 20 minutes on a notary. Hey, listen, let me tell you something. When you come into the class late, just be quiet. Don't ask no questions.
He gonna take your head off.
Yeah, you know what I'm saying? Walk in class, you know what I'm saying? Class been going on 45 minutes and shit. Mother come in, want we recaps and shit. You know, it's like, nah, we ain't doing that. We ain't going back. All right. So right now we're reading a letter. We got a bill of exchange. That is going to be the preferred method of discharging a debt, the preferred negotiable instrument. I would also advise you to read the United Nations Conference on International Trade Law with bills of exchange and promissory notes. The very first 7 articles identify what elements need to be on a negotiable instrument. Please don't ask me what right now, but you need to download that. The document is available on the internet. All you need to do is Google it, put in the United Nations Conference on International Trade Law on bills of exchange and promissory notes.pdf. It will pop up. Download that. Keep it. I might have it on SBC University. If it's not on there, it will be on there. I got to put that on there. All right. So once again, we're going to read the letter. Now, with our negotiable instrument, we're going to give it to the notary. The notary is going to mail. Going to put it in a package, send it registered mail. All right. And this is the cover letter that's going to go on it. It's going to say, as it is my intent to expedite this process, to reach settlement and closure of this matter as soon as possible, I've accepted your letter demand or whatever it is for value or assessed value, endorsed it, and I'm hereby returning it to you in exchange for the discharge of the charges using my exemption number, which is your social security number without dashes. I do not dispute any of the facts. My records indicate the balance on the account is, and then you're going to have that account number. You're going to say it's a zero balance. It's called a statement of account. If you have evidence to the contrary or that my process for settlement is prohibited by law, please send a full accounting or the prohibiting law upon which you rely to the notary identified above within 10 days of your receipt of this notice of my acceptance. If you have no reasonable commercial excuse for delaying the settlement of this account, please settle and adjust your records and send confirmation of same to the notary identified above within 10 days of your receipt of this notice of my acceptance. In the event you choose not to respond to this notice and request, I will accept your silence as your agreement that the balance on this account is zero, and I will settle the account myself through registration. The registration is that we are going to be filing UCC 1s all through this process. All right. This is how you do the proper documentation that many of these people out here who are discharging debt aren't telling you. Okay. So let's go to the next page. Okay. You're going to have a certificate of service, or you may want to choose to use an affidavit of mailing. My preferred method is an affidavit of mailing, but you can use a certificate of service. All this document is, it is like a verification from a notary that that particular notary is involved and that they are the one that are actually doing the mailing of the process. All right, now, the next one is a UCC1. Now, after you mail this bill of exchange with the cover letter, you are going to file a UCC1. The UCC1 that you're going to file, okay, is basically making yourself as the debtor. Yes, you, because they have a claim against you. All right, so you are tracking this whole process. Now, let me tell you another place you can do this at. Believe it or not, in the Better Business Bureau Commercial Registry. They got the same type of deal going on. I know you don't understand it right now, but what it is whenever there's a dispute, okay, they have a public chamber, commercial chamber, where we can start keeping track of people's responses or how they're responding to a dispute. So right now, the reason you're filing the UCC1, you're going to put yourself as the debtor, and whatever company say you owe them the money. So let's say if it's a mortgage company, okay, you're going to be the debtor. The mortgage company is going to be the creditor. All right, you're filing this UCC1 as a notice to the entire world that this mortgage company has a claim against me saying that I owe them this money. Now let's look at the verbiage in the collateral description of this UCC1 that you're filing. The following property is entered into the register, into this register as collateral for a debt. All property held in the name of your all caps name, pledged as security for the debt and secured party claims is owed in the amount, and then you're going to put the account number until such time as this claim is shown to have no validity. The value of the claim is, and well, of course, we're going to get the value of the claim off of your 30-day payoff notice or 45-day payoff notice. That is the number. That's where it's coming from. Okay. In the event said claim is shown to have no validity, debtor will terminate this financing statement. The security agreement supporting this financing statement is purported to be a letter. Now, when they send you a dunning letter is saying that you owe money. That's the same as a security agreement, because it's establishing letters or contracts. Ask an attorney. Letters or contracts. Because it tells you right in there that, hey, if you don't answer this, it's going to be presumed that the debt is valid. So we're going to file this UCC1. The reason we're filing the UCC1 is now we're going into the public and giving public notice to the entire world that there is you are resolving an issue as it relates to a debt, and you're tracking this. Now, let me just tell you something. Can anybody claim that you are doing something illegal or defrauding someone when you're giving them a notice every step of the way? It's called mens rea. It's called criminal intent. You have no intention to defraud anyone or to do anything illegal, because every step of the way I'm giving you a notice of every step that I'm taking. I'm noticing the Treasury Department of what's happening. I'm noticing you what's happening. I'm filing the UCC1 in the commercial chamber. What are you I'm not putting any routing numbers on my instrument or anything like that. I'm not using anything that belongs to the public. I'm a private creditor, a private citizen of the United States of America, a Moorish national, however you want to say it. Okay, I'm that individual that has all the power. I'm that person that you serve. I'm that person that has substance. I'm that person that you get all your credits from. I'm that person that you need my signature from that makes commerce go in the public. So don't sit there and act like you don't understand what the fuck I'm talking about. Okay? Quit playing games and let's get down to what's really going on.
Right. Hey, can you get that verbiage in that UCC, the following property is entered?
Okay, it's on page 22.
22, yeah.
All right? And you see right there under section 4, the financing statement covers the following collaterals in the collateral description. So your verbiage is right there for you. You can copy that same exact verbiage. You're going to file that UCC1. You're filing that UCC1 to memorialize the fact that you've already sent them a negotiable instrument and you are attempting to equitably settle a debt by discharging the debt by tendering them a negotiable instrument. You're taking private credit and using it to offset a public obligation.
And documenting it on that.
And I'm documenting it on the UCC1.
When it says secured party claims, it's owed on account number.
The secured party is the bank. Let's say we're talking about a mortgage company. Okay, they sent you a letter. All right, that letter is like a security agreement. Okay, the secured party in this instance would be the bank. So you see that you put yourself as the debtor, and you put them as the creditor, because they say what? You say, oh yeah, y'all say I owe you some money. My straw man owes you some money. So that's all the cap, all Cap's name is going right there, not you. Okay, so we're going to resolve this issue. Okay, I'm going to memorialize the fact that you just sent me a letter saying that I owe you $200,000 for this mortgage. All right, I'm going to put it on a UCC1. Okay, and then this verbiage, it says, now this will remain until the fact that we resolve the issue and determine that the debt is no longer valid. At that point, you're going to file what's called a termination statement. And we're going to get that. We're going to terminate this. All right. But before we do that, we're going to go through the administrative process first and allow them an opportunity to rebut anything that we're doing. Under the UCC, one of the principles is mistake. So you don't never get into an argument with an individual who doesn't discharge something for you. Because when you send some correspondence to someone, well, what may have happened? Okay, well, what if they lost it? Okay, this is why we give them another opportunity. This is why you send a second letter the second time. You don't know what happened the first time. Some employees might have got fired. You know, it might have dropped on the floor. All right, don't automatically assume that your public servants are dishonoring you. All right, always give them the benefit of a doubt. And it's some very beautiful verbiage for that we have coming up next. All right, so we got the UCC1 file. All right. We also have a cover letter from the notary if we have the notary mail it in. That's not necessarily. You may want to do it yourself or just go online today. We can do it. All right. Now, let's look at your notice and effective failure to respond. Okay. Now, this right here is like a notice of default and opportunity to cure. This is going to be your second mailing. Okay. You mailed them the cover letter. You mailed them the negotiable instrument. You sent it registered mail. 10 days has elapsed. You haven't heard anything back. Now we're going to send them a second letter. We're going to give them an opportunity to act honorably, okay, and respond to your correspondence. All right. So the notary also mails this off. Once again, you don't mail anything. The notary is the person who mails it. Once again, why do we have a notary mailing something? Because the notary is a witness. In court, you need two witnesses. All roads lead to court. You should do anything that you're doing in contemplation that you may have to end up in court. And in court, you need evidence. And in evidence, you need things attested under penalty of perjury. Evidence constitutes affidavits, testimony in open court, deposition, or some sort of notarized documents. Those are evidence. Everybody got that?
Got it.
All right. All right, so what are we doing next? Notice and effective failure to respond. Let's read this real quick. Now, the verbiage on this is excellent. Very excellent. It's on page 24. Okay, if you're using a PDF viewer, you're going by the page numbers at the top of the viewer. So on page 24 of Creditors and Their Bonds, we downloaded it from spcuniversity.privatesidesolutions.com. We went to the resource tab on the website, went down to the PDF section, downloaded the document, and now we're on page 24. Y'all following me on Instagram. All right. So let's read this next section and see what it's talking about. All right. It says, regarding instrument, now we're going to put the registered mail number the first package that we mailed it, we're going to reference that number in the first paragraph. Received on you by, and we're going to put the date it was received by. How do we know what date it was received? Well, usually we'll either get the green card back or we can go to the U.S. Postal Service website and we can look on there and tell whether or not registered mail or certified mail has been received by the correspondent. All right. So as consideration to settle this account, I have not received notice that the account has been adjusted. They ain't got back with you yet. Somebody said they're trying to keep up. Don't worry about keeping up. It's recorded. If you don't know how to download videos off of Instagram, go to Google and put in Instagram video downloader. They got online ones. All right. You click on that little 3 dots on this video. Okay. It's copy link. You take it over there to the download and you download this shit to your computer because I'm going to erase it in about a week. So now we're going to deal with 4 presumptions, because everything operates off presumptions, assumptions, and color of law. I hope you do know that. So there are 4 presumptions that we have to contend with when we are going to discharge debt. Because usually when you discharge debt, you may not hear nothing back from them in 10 days. You know, they're kind of dishonorable like that. You know, they're back in the background thinking like, how dare this motherfucker think that he ain't a slave no more? This motherfucker don't want to be a slave no more, man. Here it is. He think he a master. He think he is confident enough to handle his own commercial affairs. How dare he try to get away from the other sheep that's out there? All right? So you're not a sheep no more because you over here listening to Yusef on high frequency radio, the creator of SBC University, is teaching you all this stuff, okay? So let's get to it. Look, what are the 4 presumptions that we have to contend with? Well, when you mail something to someone and they haven't responded to you, okay, correctly, okay, let's see what we have to, the presumptions, okay? First presumptions. I presume one or more of the following statements is true. You applied the consideration and settled the account. You elected to cancel the debt. The instrument tendered to you in some manner was defective in form or substance. You received the tendered instrument and failed to ledger it and settle the account. Now, let me tell you about negotiable instruments. You will hear people say they have something out there called vapor money theory. It is a lot of court cases out there where people have attempted to discharge debt. I want you to read the cases. Okay, I don't want you to in any kind of way. SBC stands for secured party creditor. Okay, I don't want you in any kind of way to think I'm trying to hide something for you. I want you to read the cases to see other people who have gone into court trying to discharge debt and failed in it. Because what did they do? They got into an argument. And it's not for you to get into an argument because in commercial matters, there is a procedure that has to be followed. So when you're in court and you have your negotiable instrument and the judge says, you know, this is a worthless piece of paper, which Federal Reserve notes are worthless pieces of paper too, because the Federal Reserve will tell you that on page 2 of Modern Money Mechanics. They straight up told you, well, our shit is worthless piece of paper too. Okay? All right? So it's going to say it's a worthless piece of paper. And when you pause and you say, excuse me, Your Honor, but that is not for you to decide. That is for counsel to take that back to his client, and they can return it to me with evidence of a defect from a qualified third party and allow me an opportunity to cure such defect. Absent that, sir, I consider this matter settled and closed. Because they have to make presentment. Think about this. When you write somebody a check, let's say, you know, you rented an apartment and you write your apartment a check. Okay, and then your landlord come to you and say, well, look, you know, you didn't pay your rent. Well, no, I just sent you a check, man. And then he didn't take the check up to the bank. Do you know if he goes to court that the court will apply that money to your rent? Because it goes under UCC 3-603B. I've seen a judge do that where somebody accepted a check and didn't go and cash the check. It's not my fault you didn't go cash the check. So when you tender a negotiable instrument to someone and you give them processing instructions and you tell them where their credits are coming from, they won't take it to the bank because they're going to try to say, well, we don't accept this form of payment. And you're going to tell them, well, look, that's against public policy. And I to understand that you are willfully violating public policy. If a judge tells you that. A judge told me one time, we only accept a checks, credit card. We don't take cash, check, or credit card. Well, I'm sorry, Your Honor. Am I to understand that you are willfully violating public policy? Because under public policy, you cannot require me to pay anything in any particular form of cash or currency. That's against public policy because y'all are bankrupt entities. Now, how the fuck is the debtor going to try to tell me, the creditor, how I'm going to give you some money? I'll pay you. Understand that fact. Do I need to pause for a second? We're going to pause for a second. I'll take some questions now. My students had to go to the bathroom. So we're pausing for a second. We're on break. So what we got? Read from the record, never off your head. Right. Right. Another system was discharged, non-injured party matters, gun case in Macon County. I'm telling you how to discharge something right now. You need to go back and watch the video. Everything how to do criminal cases is in the same document too. They switch judges on you. If they switch judges on you, they're trying to recontract with you. You have to do everything all over again because that judge's name is not in the record. He don't have no liability. They do that. They switch judges on you. Hello, what's going on? What's going on? All right, what's going on tomorrow? You must be feeling generous to give this game for free. I mean, well, it's like, I'm not giving everything up for free. Y'all still going to need to come and get some questions answered because you ain't going to understand all this stuff just like that. You don't understand it. You ain't going to get it. Some people will. Some people get it. It's always about, if you give it to 10 people, it'll be about 2 of them, they'll run with it. The rest of 8 ain't going to run. But you get about 2 of them, they'll run with it. They'll figure it out and like, okay, I got this shit. And they run. I was one of them kinds of runs. I was like that. I run with it. I get the game like, shit. Yes, I am. I'm doing that right now, as a matter of fact. That's why I'm live streaming. I'm actually got people here right now that I'm doing the 3-day thing with. And, I just wanted to, while we talking about it, they actually here right now. And I'm just live streaming, talking about this with them. And when I get through, I'm going to get a little bit more detailed with them. But right now, this is like a lecture. And I'm giving them a lecture right now on the discharge of a debt. Yeah, it's recorded. It says, should the letters be sent to the individual that sent you the payoff for the CFO? You're going to send it where it tells you to send it to. You need to read UCC 3-311. All right? You got to read it. Send it where they tell you to send it to. What I usually do, though, is I will send a copy to the I send it where they tell me to send it, and I send another one to the CFO. Because the CFO knows what it is. But I always make sure that I cover where they tell me to send it to, too. I usually send 2 packages. I'll send one to wherever that payoff statement tells me to send it, and I'll send another one to the CFO of the corporation. Because under UCC 3-311, that's a rule right there. But it's also understood that the CFO and the CEOs are the only one that really knows what's going on. None of them employees know what's going on. And that's what you got to contend with, too, the ignorance of the employees who work at a lot of these corporations. They don't understand what's going on. They do what they're told. You got to understand, when you deal with people that do what they told. Y'all some employees out there. Some of y'all listen to me. Y'all know y'all employees. Y'all know y'all do what the fuck y'all told. Look how y'all out there getting vaccinations and shit. These motherfuckers telling y'all this is an experiment. You still doing the shit. I'm just going to do whatever you tell. Do what the fuck you told to do. All right? Just do it. Well, watch the Matrix with the Merovingian. When he told Neo and Morpheus and Trinity, he said, you came here because somebody told you to come here. Now take your ass back and run back over. Somebody told you to do this shit. And you know why I'm talking about like this right now? Because ain't nobody on here should do nothing because I'm telling you to do it. Don't ever come in my face, well, you told me to do. No, I told you something, and your ass should have did due diligence and researched the shit. Don't do shit I tell you to do, because I don't. Understand that. Prosecutors don't play stupid. They are stupid. He said, yo, user, pin your website here so we can ask. I don't know how to do that shit, man. Y'all, somebody else do that. Put my website up and pin. I don't know how to do that shit. I ain't figured out how to use Instagram. I'm not really an Instagrammer like that. I'm trying to get my 10,000 followers, and y'all ain't following me or nothing. I'm giving y'all. Now, you supposed to press like. You supposed to share. All right, and follow. Because I ain't asking you for no money. That's the least you could do. So how do you redo your SPC process if you've done it in prison and didn't do anything? Do it again. What do you mean how you do it? Start all over. Ain't gonna hurt you. Look, listen, man. None of this is fatal. None of this is written down. All right. You can listen to a lot of people tell you that this is how you're supposed to do it. But I'm going to tell you straight up, ain't none of this shit written in stone. I ain't seen no instructions written down nowhere for none of this shit. All you can do is kind to listen to people who've taken the time to go and research and study this information and convey it to you, all right, the best that they can, all right? None of us are 100% on all of this stuff. All we know is we got certain principles. We know there ain't no money. I know that. I know there's a public and private and it don't mix. I know that I have to be honorable in all my dealings, and I need to be careful when I engage in public controversy. Those are the 4 rules. You need to know those 4 things, because everything that we're dealing with is dealing with those 4 things. Thank you. Thank you. Somebody put that. You can take the log on part off with the SBC University unless you're a member. If you want to be a member, we do classes Monday, Wednesday. Well, I'm doing classes Tuesday and Thursday right now. All right, I might switch back to 4 days a week. That was killing me for a little bit. But you can go to classes, you can register, and so you can go like get a gold membership or a platinum membership, and you can come and come to the classes. All right. So let's
platinum membership. I got that. And that's why I'm here now. sitting right here with the man, getting it right there out the dirt, out the mud. So yeah, y'all get them memberships, man. Get with my brethren here.
All right.
You know what he's doing.
All right. All right, so let's look at this notice and effective failure to respond. Now, we just went over the 4 presumptions that you will have to contend with when they have not cleared your debt. Now, you sent in a bill of exchange with a cover letter. You waited your 10 days and nothing has happened. You're looking on your account, the motherfuckers ain't zeroed it out. All right, now you're getting upset. Oh, they disrespected me. Oh, it didn't work. Oh, it was no good. No, you maintain your calm and you always give them a benefit of a doubt. They made a mistake. All right? So let's see what mistake they made. Well, it could have been one of 4 things, okay? They didn't apply the consideration to the account. Or they did apply it to the account and just ain't told you yet. Or they elected to cancel the debt. Or the instrument tendered to you was in some manner defective in form or substance. Or you received the tendered instrument and failed to ledger and settle the account. Now, if there is something wrong with your negotiable instrument, they have a duty to return it to you, and that's called a notarial protest. All right? They should use a notary to send it back to you and say, hey, look, this instrument is something wrong with it. You didn't sign it. You didn't date it. Okay? There's no money in the account. It could be a number of different issues. But they have to inform you of that issue, and they have to allow you an opportunity to cure any defects that you have in your instrument. This is how commerce is conducted. And this is the same information that you will tell a judge in court. You're not going to get into a confrontation with a judge about the value and validity of a negotiable instrument. All right? The only thing you want to talk about is, did you make presentment on the instrument? And if you made presentment, where's the protest showing that it was what? No good. They can't do that. You know why? Because there ain't no fucking money. There's no money. Yes, ma'am. Are you okay calling me not saying nothing?
That phone must be fucked up or something.
She keep butt calling me and shit. Hold on, man. Can you stop butt dialing me? I'm live streaming. Well, why are you calling me and holding the phone and breathing all on the phone and shit? Breathing on the phone. She calling me, y'all, and just holding the phone. And then talking about I'm trying to do that.
Oh, she's not because you're that sexy.
I sent you the document, okay? You got the document in your email, all right?
Oh, you signed it?
Yes, I did.
Okay.
Because he told me to email it to you. That was in the instructions. Okay, well, I'm live. I'm in the middle of something. You got to call me back. All right, bye. All right. Act like she my mama sometime, boy. I ain't playing. All right. Now, once again, we got to go over these 4 presumptions. Okay, hold on. Let me give you a caution on an automobile. Let me caution y'all about automobile. Now, when you try to discharge an automobile, you need to make sure that automobile is put up somewhere, because a lot of times they know what's going on. They'll come and try to get the car and hold the car and then take you to court and let y'all argue about it in court. But they only want to argue about it in court if they got possession of the vehicle, because possession is 9/10 of the law. And now they can always come and get a vehicle if they deem their security interest is jeopardized in some kind of way. Because in every car contract, they got what's called a confession of judgment clause. You need to get your contract out of your car contract and understand what a confessed judgment is. What a confessed judgment is means that they can come, they don't have to go to court to get the car. Now, they cannot breach the peace to get the car, which means you can put it in your garage also, all right? Or even if they do come and get the car, anytime you see somebody repossessing your car, if you're right there when they're repossessing it, don't stand over there and watch the motherfucker put it on the truck and take your shit away. What the fuck is wrong with you?
Right.
All right, it ain't no reason to give a car back. I don't give a fuck if you didn't pay for the motherfucker. Why would you give it back? Okay, you would give the car back, they're going to still put it on your credit report, dumbass. I'm going to get in the car. I think I'm going to go get him this car back. I'm tired of, and they ain't going to make you pay for it. Okay? Don't give them a goddamn thing back. And if they jacking it up on the tow truck, you jump in that motherfucker and sit. They cannot move the car if you sit in it. Call the police. The police can't do nothing. All the police gonna do is sit there. They may try to talk you out the car, but just look at the police and say, no, nigga, put this car back down on the ground. It may go on for about an hour, but they're going to put it back on the ground and take their ass on. Because they cannot take nothing by breach of the peace. And the only reason a law enforcement officer is there to make sure that there's no breach of the peace. Because it's a civil matter. Okay? So if you're going to discharge a car, put that motherfucker in the garage. Now that costs some money right there. I should charge for that shit. Let me give y'all my donation. It is $. Well, okay, what PayPal.me/Yusef. PayPal.me/Yusef. And then we got my Cash App is $Yusef19. You know, 19 is a seal. 1 is the lowest number, 9 is the highest number. All right, Yusef19. That's my Cash App. And then my PayPal is paypal.me/Yusef. Okay? Send me some money. All right? Because I'm giving up game.
That's right.
And stop being cheap. All right? You have to give to receive, nigga. All right? That's how it go. All right?
That's the law.
So let's look at the 4 presumptions of, why they didn't discharge your debt. And this is what we're going to ask them. We're going to ask them these 4 questions. If you apply the consideration to the account by ledgering it and therefore settling and closing it, I will assume you just forgot to notify me that the account is settled and closed. If you elected to cancel the debt, whereby ledgering the account was not necessary, I will assume you just forgot to notify me that the debt was canceled or you canceled the debt. If the instrument tendered, now this is a good one right here. Because this one is going to go over the fact, they said there's something wrong with your negotiable instrument. It's not a valid instrument. Okay? If the instrument tendered to you was in some manner defective in form or substance, then I will assume you received a certificate of protest / notice of dishonor from the drawee and you forgot to send it to me or send me a copy. I assume you will agree that your failure to send a copy to me resulted in a violation of substantive due process, but we're talking about due process. I had a judge tell me straight up in court, you right, Mr. Jones. Because when I told him, he said, I've seen thousands of these, and this is a worthless piece of paper. And I told the judge, I said, excuse me, Your Honor, but that's not for you to determine. That's for counsel to take that back to his client, and they can return it to me with evidence of a defect from a qualified third party. Absent that, sir, I consider this matter settled and closed. And he said, Mr. Jones, you're right, but they ain't going to follow you down the rabbit hole. I won that day. Because I didn't go in there talking about, you had a duty under HJR 192. Y'all know y'all bankrupt. And no. There's a procedure that you need to follow. You need to follow the procedure. Once you get that procedure followed and there's no violation of substantive due process, then we can get into discussion about that. but you need to make presentment, and then you can return it to me with the evidence of a defect from a qualified third party. Maybe that's a notice of protest from a notary or something from the drawee. The drawee, okay, which would be the bank or the Treasury Department in this case, showing that this instrument was no good. That is commerce. So I assume you will agree that your failure to send a copy to me resulted in a violation of substantive due process rights if, in fact, you have in your possession a certificate of protest / notice of dishonor to the instrument by your failure to send me a copy of this notice so I could correct any errors to the form or substance of the instrument. I assume you've accepted liability on the debt, because if they don't follow substantive due process, they liable. You gave them a negotiable instrument. You did what you were supposed to do. See, this is what y'all got to understand. It's not for the court to determine value. Value is determined by the parties who were involved in the transaction. Hell, Dodge may say, you know what, Mr. Jones, just give us a bag of marbles and we'll write off that fucking Hellcat red eye for you and everything. You know what I'm saying? They may accept that shit. That's not for the court to determine what value is. That's the parties that determine what's valuable and what's not valuable. The court is supposed to be an unbiased arbiter in the dispute between two opposing parties. There's a judicial code of conduct that they got to follow. Hope y'all got that part. So right there, we can see that, okay, the third presumption, okay, well, I'm guessing, that if you do have a certificate of protest or there's something wrong with the instrument that I sent to you, then, I'm going to expect a notarial protest or something to that effect that's going to let me know that. Because absent that, without any notice that something's wrong with the instrument, I can only presume that you accepted liability on the instrument and this matter is settled and closed. And then we have a fourth one. Go ahead.
No, I was going to say, what I would correlate that process to what they can relate to that's happened to all of us.
What is that?
You get a presentment from a bill and you don't respond. And that's when the lawyer's in court on the docket saying, oh, I move for default judgment.
That's right.
And then what? You got a judgment on you in the public record because you didn't respond or show up.
And that's why you documenting everything. Because you have to be able to document on the record that they didn't respond. Mm-hmm. They didn't give anything back. That's also the reason why they like to call you on the telephone. You don't do no business on the telephone. All right, when a debt collector starts calling you on the telephone, as soon as you pick up the phone and they say, is this John Doe? You don't never say yes. You don't never, anytime anybody calls me and the first thing they say when I pick up the phone, is this my name? Okay. I'm so habitual with it. I say, what is this? What is this? Who is this? And what is this involved? I don't answer any questions. I ask all the questions.
Yeah, that's what I do.
I say, who is this? Why are you calling? What is this regards to? And then when I find out it's a debt collector, I say, I don't do business over the phone. Yeah. Okay, and if they start pressing the matter, I start asking them for their personal information. I say, okay, well, sir, I need your name.
And your ID.
I need your ID, your social security number. Why you need that? Because I'm finna file a lawsuit against you. Because under the Fair Debt Collection Practices Act, once I tell you on how I want to correspond with something, you're supposed to end it right there. And right now you're in violation of that, and that's like $1,000 per violation. Yeah. I need to get that money up out your ass, so I'm going to contact you. Click.
You're right, that's the first thing. Is this so and so?
All right, so let's look at the fourth reason. If you receive the tendered instrument but fail to ledger it to the account in 30 days, then I will assume as a direct and proximate result thereof, you have converted my tender offer, and by that act of conversion, you are liable to me for the face value of the instrument, because you're the holder in due course of that instrument. You found it on the UCC1. They got to return it to you or the proceeds.
They can't just discard something of value.
Exactly. You can't discard something of value. Yeah.
You took my money and you didn't say nothing.
Well, it's a debt instrument, and I have an obligation on it, and regardless of how they feel about it, you just don't take my instrument. I got a claim on it. Now, claims to an instrument is UCC 3-306 and 305? UCC 3.
306 and 305.
What is UCC 3-306? Claims to an instrument, and UCC 3-305 is claims and recoupment. Okay, those two relate to when you issue an instrument. Okay, you have the right to recoup the proceeds of that instrument or the instrument itself.
It's powerful.
That's why you put it on a UCC 3, all right, which is an amendment, all right, because that constitutes a claim, all right, and you can send that UCC 3 with your negotiable instrument also to them, and that's giving them notice, because you got to give them notice that you put a claim on the instrument. Okay, it's just like, I'll tell you what it's like.
A 1 and a 3.
Yeah, well, you know, you initially filed a UCC 1 when you did your secure party process.
Right.
When you issue an instrument, you always file a 3 every time you issue an instrument, and that's a collateral add, because that instrument is your property, and so you're adding it as collateral to your property already on your UCC 1. Okay, so the thing about it is like, I'll give you an example of a scenario about a negotiable instrument I always like to use. Let's say I'm walking down the street and somebody's walking in front of me, or somebody's walking behind me, and I drop $100 bill on the ground, and somebody behind me picks it up, and I turn around and say, man, that's my negotiable instrument. That's my $100 bill. And he said, man, I don't know what the fuck you talking about. And then I see a police officer. I call the police over. I say, officer, I just dropped this $100 bill on the ground, and this gentleman picked it up, and he doesn't want to return it to me. And the officer is going to ask me, well, sir, do you have proof of your claim? So how am I going to prove that I had that instrument? Now, I might, you know what, say, well, you guess what? I just so happened to have been at Office Depot and made a photocopy of it. And I pull out a photocopy out of my pocket, and it had the exact same serial numbers that's on that damn $100 bill. Now I got some kind of way, I got proof that at some point that instrument was in my possession. And what are the chances of that? So now I got some sort of proof of my claim. Well, that's what you do with a UCC 3. You got to understand, these are negotiable instruments. Right. They circulate all the way around the world. They change hands constantly.
Documents your instrument.
Yeah, so but in order to be the holder in due course, you got to give any subsequent holder of that instrument notice that you have a claim on it. And that's why you put it on a UCC 3.
Right.
This is the holder in due course rule. And that's why you got to understand UCC 3-302 and UCC 3-305 and UCC 3-306. When you read UCC 3-302, it references UCC 3-305 and UCC 3-306.
Which one pertains to holding in due course?
Holding in due course is UCC 3-302. Claims and recoupment is UCC 3-305. And claims to an instrument is UCC 3-306. We're doing the 101. This is what a 101 is like. How is your accommodations here with me so far? You can tell. You don't have to be on camera. You just tell.
Look, hey man, when I came here, I was like, man, it's nice, man. I told him, I said, damn, it's nice. I might, actually, I may be staying here. So y'all be careful. You come out here, it'd be like on Harlem Nights. You call your wife, say you're never coming back. But yeah, I'm gonna end up staying out here with Yusef in the accommodations because I've been looking for a place in Atlanta, and it so happened the brother got he got things in order here too. It's a reflection of him as a whole. You see how he accommodates his clients, then you will see that the reflection of his integrity. You know what I'm saying? How he do business, because you ain't gonna come here being no raggedy, or
I ain't gonna put you that raggedy.
It's to the point where, like I said, look, we have to talk about making arrangements for me to stay here in those accommodations where I won't even have to find something for myself. So everything works for the good of those who do good.
I appreciate that. I appreciate that. All right. I would like to see one virtual blessing. Okay, would you like to see for myself though? Okay, cool. All right, proof of claim. All right, you already know. Okay, cool. All right, y'all following. We following along. Okay. All right, cool. All right, let's keep it moving. So let's recap real quick. Recap once again. All right. When we started off with the IRS employee manual We wanted to look and see what the IRS had to say about promissory notes and unacceptable forms of payment, as well as what they do with bills of exchange when they receive them. Okay, to go to the Treasury Department. If you request that they settle an account and use FedWire for the satisfaction of the obligation. If you ever see my bills of exchange, you can see that it has FedWire on there, and it's for full settlement of an obligation. All right, that's number one. Okay, the next thing we had to go get a notary. All right, your notary needs a notarial record book, as long as 2 stamps. They need the crimper as well as the stamp, and they need their own post office, and all of your correspondence goes through a notary. All right, you also need to know how to put together a negotiable instrument. I told everybody to download a copy of the United Nations Conference on International Trade Law on bills of exchange and promissory notes. It is a PDF on the internet. The first 7 articles of that particular document tell you what elements need to be on a bill of exchange, as well as Article 3 of the UCC. Okay, so we got that. We did a cover letter. We sent a notice to the Treasury Department and let them know that, hey, we are about to discharge some debt. Here's the account that's going to get discharged. So we're going to give the notary, the Treasury Department a head up, and we're also giving them an authorization to settle our accounts through the Treasury Department. In case you don't know, everything in this country goes through the Treasury Department. Everything. Everything is an account. All right. And then we sent a cover letter with a notary along with our negotiable instrument to the so-called creditor who has a claim of interest against our straw man. And then we waited 10 days. That 10 days constitutes 3 days mailing time. 3 days after you receive it, what you're going to do with it. 3 days to mail it back. 1 day for Sunday. They didn't respond at that time. There's a principle of silence is acquiescence. So we're going to send a second notice, which has 4 presumptions. We're going to presume, we're not going to get upset. We're going to presume that the reason they haven't settled our account yet, that they made some sort of mistake, or maybe there's some sort of inefficiency going on their side. Why would you not think anything else? The only reason you would think something else if you didn't believe in what you were doing. But if you believe in what you're doing, okay, when you talk to these people, your whole attitude would be, hey, what's going on? I gave you a negotiable instrument. Why have you settled the account? Friendly reminder, in order for the process to be valid, you must be operating in the private by filing your UCC1 financial statement and becoming a secured party / creditor. There's no such thing as a secured party creditor. It's a secured party. And a secured party is a creditor. All right? Good. All right. So we also went over the 4 presumptions. You know, it's like, okay, there only can be 4 possible reasons you have not discharged my debt. We're going to concentrate if there's something wrong with you just forgot to tell me. You forgot to tell me you canceled the debt. You forgot to tell me that you ledgered the account. Or if there's something wrong with my instrument, then there's a failure in due process because you were supposed to make presentment and then come back with a certificate of protest from a notary or something of similar import and let me know that my particular process is invalid in some kind of way and allow me an opportunity to cure any deficiencies in my process. All right, we got it. So we did, the first step was the presentment of the negotiable instrument. The next one was a notice of default and an opportunity to cure. So what we're going to do next? What we're going to do next is we're going to file another UCC1. Well, I'm sorry. No, we're going to do an affidavit. Now in commerce, all debts have to be attested to under penalty of perjury. Y'all should understand that when you go into the courtroom and like you have a third party debt collector, these attorneys, a third party debt collector don't have no entitlement right to anything from you. And it's a big money maker for the attorneys. And the only reason it's a big money maker for the attorneys because 85% of the people out there, when they get a letter in the mail from a third party debt collector saying, yeah, you owe this debt, y'all don't answer the motherfucker. So they defaulted. 85% of these people, they get money off of you and getting a judgment through the court through default methods because you're too scary to answer. And that's why the third principle of the rules is you have to stay in honor at all costs, which means that you have a duty to respond to something. You got to respond to it. You don't remain silent. You know you signed that contract and got that loan. Now they done sold it to somebody else. You don't even know who the fuck this is. You send them, you do an administrative process against them. You know what I'm saying? Okay, well, if you're the creditor on this, I need you to sign an affidavit attesting to that fact from your CEO, because the CEO is the only person that can bind the corporation, not the employees.
And when they don't do that, you follow their process of non-response.
You follow the process of non-response. Everything before you get to court, you want to demonstrate to the court that you did everything possible to resolve the matter without having to go to court. Everybody think that the first thing is for you to go to court. No, two grown adults or two business people should be able to resolve their issues amicably without going to court. Court is the last resort. But I'm going to document. If I'm going to go to court, I need to have evidence. So I'm going to document everything I did along that way. Okay, I'm going to take a break, y'all. And we're going to come back later. I'm going to take a break. How long I've been going?
I've been over hours.
About 2 hours. So I'm going to take a break. Y'all going to have to catch the next one a little later. But I did give y'all a lot of information so far. All right. And we're going to go into the rest of it. How to make your presentment on your negotiable instrument. The last step, is that you're going to file a certificate of non-response. And then you're going to go into some sort of court process. All right. But you have some very valuable information, and you have the document I've given you, because I'm just going along with this document. You can choose to read that document yourself. It's a very interesting document. You need to pay attention to everything. You need to read the first part of it and understand the principles that are involved behind what you are doing. Okay? Peace to the guys and goddesses. Men be men and women be women. Peace.